What are employee and intellectual property matters that must be dealt with early on in the formation of a business entity? Well, to begin with, your employees. Generally, an employee is either going to be subject to an employment agreement, which has all of the terms of the relevant employment in the agreement. It will establish the rights of the employer and the rights of the employee in terms of compensation, assurance of continued employment, nature of work, duties, obligations, things of that nature. Now, most employees across the United States are not subject to an employment agreement. These employees are called at will. That is, the employer has the ability to discharge the employee at any time, and the employee has the ability to quit and go to another job or not work at any point in time. These are known as at-will employment relationships. So if you want to make certain that you're establishing an at-will employment relationship with your employees, you should enter into an at-will employment agreement at the beginning. This, while it sounds like an employment agreement, really what it is an agreement where both parties acknowledge the at-will nature of the employment relationship. Next, you'll want to have any employee, any contractor sign an agreement, or in the at-will employment agreement, have a clause in there that states that any information received, created, generated, any inventions, intellectual property created, trade secrets learned, things like that, are and remain the interest or property of the employer, not the employee, not the contractor, etc. Okay. Now, you will oftentimes as well have many independent contractors working for the company. These are individuals who provide services to the company but are not considered employees. Think, for example, an accountant that does your taxes. They are not employees of the company. They have their own business. You are hiring them for that service that they provide to the company. You may have an independent contractor agreement with that service provider. And again, you should have very similar provisions such as proprietary information and inventions clauses in that independent contractor agreement. For employees and independent contractors, you may wish that they not disclose certain information that they receive as part of the employer-employee contractor relationship. That is, they keep it confidential and quiet. They do not disclose it to third parties. In some situations, it may be necessary to ascertain that the employee or contractor is not going to compete with this employer at some future point in time or during the employment engagement. That is, they are not going to use the information or services or approach clients that otherwise are clients of the business as part of the process. So you'll enter into non-disclosure agreements that keep the employee from disclosing information to third parties. You'll enter into non-compete agreements that say this employer contractor will not provide this type of service to other businesses of this nature for a certain period of time and within an established geographic boundary. Also, you may have a provision in there known as non-solicitation. That is, the employer contractor will not solicit clients or employees of the employer to, again, compete with in some way or leave the company to go with that employee or contractor if they are going to go outside the company and provide services. So you will not disclose, you will not compete, and you will not solicit employees or clients of the current employer. And then lastly, you will want to make certain that all founders of the company, initial owners of the company who are capitalizing the business, assign all of their intellectual property that they've created over to the business, because oftentimes the founders have created some level of intellectual property, that is trade secrets, copyrights, patents, trademarks, that type of thing, in their personal name, that they own it personally prior to forming the business entity. So you want to make certain that that ownership interest is transferred over and belongs and is held by the business entity. So this is a very important part initially setting up the business venture. So these are the primary types of agreements that you are going to enter into with employees, contractors, or founders at the very beginning that constitute employee and intellectual property matters.